All right, it's 4 past the hour. I think we can go ahead and start. Welcome, everyone, and thank you for joining us today. We will be talking about helping Afghans adjust status to green card holders. And our panelists today, my name is Emily McCabe, and I am Pro Bono Counsel at the ABA Commission on Immigration. And I am joined by my wonderful panelists, Chelsea Mack, who is a mentoring attorney at VECINA, and also Kristen Nilsen, who is a mentoring attorney at VECINA. And a quick overview of our agenda today. We will first discuss a quick background and context on Afghans fleeing Afghanistan, and then we will discuss common pathways for Afghans to qualify for adjustment of status. And then we will talk about adjustment of status generally for asylees, refugees, and special immigrants. And then we will quickly overview what it's like working with clients. And then we will talk about some pro bono opportunities for Afghan adjustment cases, which will be mentored by VECINA. Okay, so some background. As many of you likely know, on August 15th, 2021, the Taliban took over Kabul, Afghanistan after 20 years of US occupation. The Taliban takeover forced an estimated 3.6 million Afghans from their homes, and there's approximately 100,000 Afghans who came to the US through that. Also, as many of you likely know, there is no automatic path to permanent lawful status in the United States for Afghans who fled the Taliban takeover. The Afghan Adjustment Act failed in Congress, and the future remains in the best light unclear for future legislation in helping our Afghan community members. And there are some common cases that do lead to permanent status for Afghans, and those include refugee, asylum, and the special immigrant visa, and we will talk about all three of those in just a moment. And I will pass it over to Chelsea.
Thank you. So we want to just give a really quick overview as far as with Afghans specifically in this particular population, what are going to be the common pathways or the common statuses that they have in order to apply for adjustment of status. Just generally speaking, for the application adjustment of status for someone to become a lawful permanent resident, there are many different avenues or pathways that someone can follow in order to achieve that status. For Afghans, what we're seeing specifically with this Afghan evacuee population, they're generally falling within three categories, being refugees, asylees, and special immigrants. So just to give some context about refugees and asylees first, refugees and asylees all have to meet this particular definition of a refugee, and it means that they have demonstrated whether or not they they either suffer persecution or fear suffering persecution in their home country based on 5 different protected grounds. That's all provided in the law. With the Taliban takeover and what's currently happening in Afghanistan, we're seeing a lot of religion and political opinion type grounds being kind of the main focus, because those two grounds are intertwined for this particular government. But once the refugee or the asylee, once they meet, however they meet that particular definition of refugees, they are processed overseas, which is the difference compared to asylees. Someone enters into the United States and then they apply for asylum, and that's all handled here in the United States. So there are 2 different ways to kind of get to this particular definition of refugee. And with asylees, just one other note, many, as Emily was just sharing, there's obviously 100,000 or so people who were evacuated. They came here, they received a temporary parole status. And so those who were paroled in, if anyone has been hearing the terms bouncing around the last 3 years, Operations Allies Welcome or Operations Allies refuge. They always get mumble jumbled in my head. Those were particular programs that our US government established to allow these parolees to come in. So a lot of those parolees applied for asylum here. So again, as an asylee, they're meeting the definition of a refugee, but the main difference is asylum applications are processed within the United States. Refugees, that process is handled overseas. So then they enter the United States as a refugee. Next slide, please. And so when it comes to the special immigrants, and I know Kristen will talk a lot about this later and go into a lot more detail, but there's a term called SIV, Special Immigrant Visa. In 2006, Congress created this particular program for Afghans and Iraqis. And there is basically this program allowing for certain individuals who worked either employed by or on behalf of the US government or this international security assistance force in Afghanistan. And they met very other types of qualifications. They're able to apply to get this status. And then once they receive the status, they can then apply for adjustment of status, becoming a lawful permanent resident. So special immigrants, they're special. I'm just saying in their own way, there are very specific details that are attached to them. And again, Kristen's going to give us a lot more information about that later. But again, these are kind of the three, the refugees, the asylees, the SIVs. These are the three statuses we're typically seeing for Afghans. And I know within our program, VECINA, the ones that we're currently placing for pro bono opportunities. And with that, I think we are going to go next to talking about the adjustment of status process. And that will be Emily.
Thank you, Chelsea. And as a quick general overview, adjustment of status, sometimes called AOS, is the process by which a non-citizen can change their immigration status to that of a lawful permanent resident, or also known as a green card holder. And to apply for adjustment of status, an applicant submits the form I-485 to the United States Citizenship and Immigration Services, which we all lovingly call USCIS. And there are different processes, slightly different roads for folks depending on what category they are adjusting their status from. And so here is the process for refugees and asylees. If you're wondering, if you were staying up at night wondering where under the law they get to apply for adjustment of status in the INA, it is section 209. And one thing to note, for all adjustment cases, every single individual needs their own application, even minor children. And for asylees, they were granted asylum in the United States. And then for refugees, they entered the United States as a refugee. So those are the two different kind of ways that folks obtain their status. As Chelsea had mentioned earlier, for refugees, most of the fun is processed overseas. So by the time they come here, they're already in the refugee category. And so then 1 year after physical presence in the United States, after either the grant of asylum or entry as a refugee, is when they are eligible to apply for, or they're eligible to receive their green card. In February earlier this year, there was a policy change at USCIS that allows folks to apply earlier. That it used to be that you had to wait until you met the 1 year physical presence to even apply for the green card. But now USCIS has changed their policy so that you can apply seemingly the day you get your asylum grant or the day you enter as a refugee. There are a lot of practical tips and tricks to figuring out when is the best time to apply, because there have been instances where they applied early thinking that it would take a while, and were actually granted too soon, which is going to be a big issue for those folks down the road when they go to naturalize. So even though the policy is pretty open-minded and broad, in practice, it is something to discuss with each client individually and kind of get a game plan and set expectations with your clients early on. And for asylees, they must continue to meet the definition of a refugee as they go through the adjustment of status process, and folks must not be inadmissible. Which means that they're subject to some sort of immigration or criminal bar generally. I like to explain inadmissibility as something in your past that the US government is not going to like, whether that's criminal or immigration or some miscellaneous categories. And the important thing to know for refugees and asylees is that most grounds of inadmissibility are waivable for asylees and refugees. And VECINA has a fabulous course on inadmissibility. So shout out to that if you're interested to learn more. And then the timeline for refugees and asylees. So as we just talked about, asylees may adjust status after 1 year of physical presence in the United States after being granted asylum. And then similarly, but different, refugees must adjust status after 1 year of physical presence in the United States after entering the US as a refugee. And how that shakes out is refugees, how that shakes out is the asylees can wait a little bit longer, and refugees should make as much effort as possible to apply as soon as possible. And the other big difference is that refugees, because they must under the law, their application is free, which when we get to fees, will save a big chunk of change for them. And we just talked about in February how there was a change of when they accept applications to adjust status prior to the 1 year mark. And then also important to know and consider is that Afghan cases, including adjustment of status cases, they are fast-tracked. In September, USCIS stated the average processing time for an Afghan asylum adjustment is approximately 10 months. And if you look at the processing times generally for adjustment of status are well over 2 years. So while 10 months is still not fast, it is lightning speed for most immigration petitions and applications. And I will pass it back to Chelsea.
So we just wanted to show a couple of examples of documents that your clients will have to prove whatever status they have. And I know a little later we'll show for the SIVs applicants, but for asylees, once the applicant submits their asylum application to USCIS and then receives the grant, the approval, USCIS will send them a set of documents, one of them being their approval notice for the form I-589, that is the asylum application. And so you should see a redacted version of that to the left. It's usually about 3 pages, but it gives their name, their alien registration number, the form number showing the approval notice, and then if they had any family members, also known as derivatives, spouses or minor children who were included in their application, it also lists them so we can all see on the approval notice who are designated asylees by USCIS. Additionally, with the approval letter, they will also receive an updated I-94 record. An I-94 is a record that someone receives when they are admitted and inspected and admitted or paroled into the United States by Customs and Border Protection, CBP. something you can always access on the website, but when when asylee, or just say asylum seeker receives asylee status, they are given this like paper version of the I-94 with this blue stamp on it that shows that they have an asylum application granted. So these are two very specific documents that you can easily request from someone to figure out if they are an asylee. There's not really any other way that they're going to show that they're an asylee. So if they don't have these, then that probably means that their application is pending. But I will say, when it comes to our program and case placement, we verify all of this ahead of time for you. And then also with refugees, next slide, please. With refugees, similar to asylees, again, anyone who comes into the United States, admitted, inspected by our government, or paroled by our government into the United States, they receive an I-94 record. For refugees, if you see highlighted, the class of admission shows RE, that's short for refugee. They also may receive a different type of letter that they're given before they travel to the United States. But this is a very common way to figure out if your client received or entered into the United States as a refugee. So this is something you can actually pull up online. This is an exact example that we redacted just to show you what that looks like. But again, these are two common, really important documents that your client will have to have in order to prove the status and that they're eligible to adjust status. And with that, I think we're now going to turn over to Kristen for special immigrants.
All right. Thank you, Chelsea. So special immigrants, you'll often referred to as SIVs, even though that technically stands for special immigrant visas. That's just the way we refer to them. It refers to the person and to the visa. So SIVs, the people, basically they are eligible to adjust their status under the general ground of the INA Adjustment of Status 245A, and also pursuant to the Afghan Allies Protection Act of 2009. Similar to everybody else applying for adjustment, every individual needs to have their own application, even minor children. The difference between SIVs and other people who are eligible for adjustment is that they have already been vetted by the U.S. Department of State, and they have received what's called Chief of Mission approval. Chief of Mission refers back to the now defunct embassy in Kabul. They used to go through the embassy to get their chief of mission approval notice. Now they go through the National Visa Center. As part of that, they are vetted to make sure that they had, faithful service, that they had all the correct HR and supervisor recommendation letters. They go through an intense background check where they call many people who they might have worked for to assure that they did actually hold the job that they had. And when all that is done, after a very lengthy amount of time, they get their chief of mission approval letter by email. Most people who are getting their chief of mission or COM approval letter now will have also submitted a signed DS-157, so they can go straight to the adjustment of status, but you do need to read the approval letter to make sure that it has that language in there. Some of the older applications may have not had the signed DS-157, and in that case, the applicant has to first go through the Form I-360 process for self-petitioning as a special immigrant. Another thing that is different for SIVs is that they must have been inspected and admitted or paroled into the United States. This is slightly different from asylees and refugees because they can come in different ways, but SIVs always have to have been inspected and admitted. Now, for everybody who came under the evacuation, they were all paroled into the United States, so we don't have to worry about that. But it could come up if for some reason, not through us, but if you were encountering SIV through another way, they have to have had that inspected and admitted designation. Another thing about SIVs is they cannot be inadmissible, and they are subject to the bars of inadmissibility. Most of these bars have a very high standard for getting waived if they are eligible to be waived. So they don't have the same I wouldn't say lax, but more generous waiver standard that an asylee or a refugee may have. So you have to make sure that you vet them very carefully to make sure that a bar of inadmissibility does not apply to them. They also have used the standard in waiver form, the I-601 versus the I-602, the refugees and asylees waives are used to get waivers. You have to make sure you read the right one there. We want to go to the next slide, please. Okay, so the timeline for SIVs. If you are taking a case through us as a pro bono attorney, all of the people that we're going to refer to you will already have their COM approval. So we're just going to start from there. Many of them have often gone through a long 2 to 3 year process to get this COM approval. That has involved a lot of back and forth as far as submitting documents and getting their supervisors to help and all that. But once they get that official letter, they can adjust status. They may adjust status anytime after receiving their COM approval. There's not a wait list. Technically, an SIV is adjusting under an employment-based category, but because they have their own category of visas available to them, we're not really too concerned about the visa bulletin. We're concerned about the number of SIV visas available. Currently, there are about 13,000, I believe, remaining of about, I think, with all the reauthorizations, there are around 50,000 total. We're hoping that another batch gets approved very soon, but that is still in process. But for right now, if you're taking a case through us, you don't have to worry about whether or not the visa is available. Visas are available right now. Most, but not all SIV applicants will be interviewed at a local USCIS office. They don't get the interview waivers like most asylees and refugees do. There have been cases where people do get the waiver because USCIS has been generous lately in waiving interview requirements. But I will tell you that all of my SIV AS applicants have been interviewed. None of them have gotten the interview waiver. Their cases are, they have said that they have been fast-tracked, but they have not actually been fast-tracked. They are subject to the local USCIS office interview times. So if you live in a location that has a very short wait time, then it will not take very long for them to get their interview. If you live on the West Coast like I do, it will take at least a year, if not more. I've had up to 3 years to get to an interview for an SIV. So it really varies based on the office. So you'll want to look on the USCIS website to see what the local processing times are for your office to get an idea of how long the case will take. And we can go to the next slide, please. Here is a sample of the Chief of Mission or the COM approval letter. This is one that was issued after July 2022, which is when they changed it from requiring an I-360 to saying that if you've had the signed DS-157, then you don't have to do that I-360 process. It's a little bit hard to read, but there will be a paragraph in there saying that a signed DS-I-57 is in the file and that they can proceed directly to adjustment of status. If they don't have that, you'll see at the very bottom, an unsigned DSI 517 or no DSI 57, then they must file the I-360 petition to be as an interim step before proceeding to adjustment of status. And from my understanding, I haven't done one of those I-360s in a while because of this process change. My understanding, they're still adjudicated fairly quickly because they know that they can move on to the next step. But you can't file them concurrently. You have to do the I-360, get the approval, and then do the adjustment of status after that. Okay, next slide, please.
So with the fees, just a quick note about the fees. There is, as Emily mentioned, there's a massive, hefty filing fee for adjustment of status. Unfortunately, this year, it was updated to $1,440 for adults and $950 for children under the age of 14 filing with parents. That is officially the filing fee for pretty much anyone of any category, except in this case, for refugees and for special immigrants, their applications are free, which is wonderful. Unfortunately, the majority of the Afghans we're working with are actually asylees, so they are required to pay the filing fee. However, this is just a roller coaster of ups and downs, but the good upswing is that many Afghans are likely eligible for fee waivers. They have to meet within three different categories of eligibility, based on their household income size, if they receive mean tested benefits, or if they're suffering some type of financial hardship. There's an additional form, the Form I-912, that they will need to submit to prove that and to provide any supporting documentation to establish that eligibility. I will say we have seen many successes with fee waiver applications. So generally speaking, if your client does fit into the category, it's just a matter of properly filling out the form, but it's not that difficult. We do have resources to help with that. And then neither them nor anyone else who's within their household needs to pay. Also, household size it's a huge factor when it comes to determining fee waiver eligibility for USCIS, and a lot of that's provided online. But for Afghan families in particular, many of them are larger families. So even if we see someone who might have a decent salary, if they're a family of 6 or 8 individuals, it may actually work in their favor, where their household size basically makes their pay not up to the standard for having to file the filing fee. So you'll definitely want to talk about that with your client once you are placed with the client. But also, we just wanted to note too, when it comes to the form of payment for these fees, we recommend them paying by money order, a cashier's check, or by credit card. Suggest avoiding personal checks because USCIS may vary in the time that they decide to cash the check. It could be immediately, it could be months, and we don't want to mess with anyone's bank accounts and then managing for their own family household needs. So we definitely suggest these forms of payment. All right, and I think with that, we are going to, I think it's still me. Yep, okay, and so also in the benefits, we just want to talk about the benefits for the approved adjustment case. Why is this a really big deal for green card holders? One, I will just say in general, it gives them a step towards a more permanent status. This is definitely more permanent than the indefinite asylee status or the refugee status or special immigrant. There are definitely some benefits to those versus not having status, but this is a much more better feeling, more comfortable, safeguarded status. So first, green card holders are afforded more due process rights here in the United States. And then other statuses such as asylees. I know, for example, I think one of our notes was saying that asylees, generally, if you are an asylee, you could have your due process your rights basically revoked by just a motion, rather than with green card holders, you are entitled to a hearing before any of that is interfered with. Also, green card holders, this is a step towards citizenship, which is never required, but I know many individuals may seek that out. And so once they do receive the green card, then you can generally apply for US citizenship within 5 years. For asylees, I know it's backdated a year based on their asylum grant. I think also refugees is backdated. Also, benefits such as traveling are much easier, a much more smooth process for green card holders. They don't have to apply for travel authorization, which if you are currently working with clients or you want to, we hope you want to work with some clients at the end of this, you will understand that travel is a really big deal for them. A lot of them came into the United States, especially Afghans, and basically have been stuck here ever since, but they may have family in other countries. I mean, maybe Canada, it could be Turkey, it could be some other countries that is not Afghanistan, and they want to travel. Being a green card holder gives them the ability to travel without receiving prior authorization from the US government. Also, they are able to more easily petition for family members. That is something else that is a really significant and time consuming as well as money consuming process, petitioning for family members. And being a green card holder, there's much easier pathways in place for green card holders to do that for family. Also, lawful permanent resident status doesn't expire, although green cards do. Green cards, the general green card is valid for 10 years. And so you do need to reapply every 10 years or so, again, if you decide not to apply for citizenship, but the status itself doesn't expire. One other note about traveling is that green card holders are able to travel internationally, but for Afghans specifically, they should not be traveling with their Afghan passport or returning to Afghanistan, because our government, they are very keen on making sure before someone, say, applies for citizenship, that they have followed all of the rules. And if they might see some travel back and forth between this country that they claim fear from, they could potentially revoke their asylee status, which would undo pretty much everything else that their immigration statuses and pathways have done for them over the last few years. So that's just one big flag. Of course, we don't expect you to remember all this. A lot of this is provided in our materials, but that's just something you'll want to keep in mind, and you'll want to address with them within that first meeting or so. Okay, now I think it is going to, I think it's Kristen or no, Emily, for details about working with clients.
Thank you. You had a 50-50 chance, right? All right, so now we're going to talk briefly about working with clients, some kind of tips and tricks and things to keep in mind. And the first thing we're going to talk about is cultural humility, and a similar concept is cultural competence, if that sounds more familiar to you. But cultural humility is a more holistic approach than cultural competence, and cultural humility is basically recognizing that one's own knowledge is limited as to what truly is another person's culture. And with cultural humility, the focus is on the client, their experiences, their needs, rather than the person providing the service. And recognizing that as the service provider, you are seeing them through your own lens, through your own culture's lens. So it's just kind of recognizing that we need to emphasize being respectful and curious as opposed to being judgmental. And this iceberg, I love this iceberg. It represents the some of the many, many layers of culture. And there are those that are very visible, such as clothes that people might wear, food that might be very common in certain cultures, to those that are more invisible or less visible, but still affect how we act, how we may present ourselves, such as the importance of space and gender roles, all that sort of thing, which again, we should be, when you're meeting with clients and working with folks, it's just important to keep in mind that they may have different ideas and different ways that different things were normalized when they were in their home country that they may also bring to this country. So it's just important to recognize that there's different cultures everywhere. And in addition to cultural, people are people. Some folks are, really love eye contact. Some folks don't like eye contact, regardless of whether it's necessarily popular in their culture. So it's just kind of recognizing your client as an individual first, and then seeing them being open-minded and non-judgmental when you're meeting with them, and just keeping things in mind as you work with them. And then also, unfortunately, in order to be eligible for one of these types of cases, you have almost certainly experienced some level of trauma. So this is a slide that is a quick introduction to trauma-informed lawyering, trauma-informed care, and it's important to acknowledge trauma, and that trauma looks different for different folks, and something that may be very traumatic for one individual, the same experience might not have been seemingly that traumatic to another individual. So recognizing that not only are there different kinds of trauma, but people have very different reactions to trauma, and that its effects can be long-lasting and can range. So it might be that your client client has difficulty remembering certain dates, when you're going over the I-45, there might be it might be really challenging for your client when you get down to how long they lived at an address, what exactly was the address, those sorts of things. And so just as we talked about with cultural humility, it's meeting your client where they are and just coming to the table with a lot of understanding and patience, and recognizing that where their difficulty in remembering or in explaining themselves might be very much linked to trauma that they have experienced. And also, as the service provider, it's part of your job is to create and maintain a safe environment for clients. Try to be welcoming and warm and really make sure that clients are comfortable. If they're not comfortable, even things that may seem innocuous might be a difficult subject for clients, such as on the I-45, there's a part where you list all of your family members, your parents, and your siblings. And while we might see that just as another part of the form, it might be very difficult for clients to talk about that if they've had some loss in their family or have been separated for a long time from their family. So just recognizing that and having structures in place to give your clients space. Okay, why don't you take a few minutes, or do you want a break so that you can get some water and then we can come back together, or do you want to skip this part and we'll talk about it next time? Just kind of giving them, making them feel safe in your company is very important. And similarly, demonstrating trustworthiness. And this can be done, you're building rapport with your client every time you meet with them or speak with them. So even things as simple as remembering things that they mentioned, if the first time you meet, there's a child and you ask, hey, what's your favorite class? And they say it's gym. The next time you meet with them, you can say, hey, how's your favorite class gym going? Are you doing anything fun in there this week? And there is absolutely no shame in writing things down to make you remember that about the client later. You don't have to do it in front of the client. You can wait. You can say, all right, he said his favorite sports team was XYZ, or he said he loves soccer. Great. And that again just kind of shows a trustworthiness that you care about them as an individual rather than just a case. And another tip/trick is offering clients choice and empowerment wherever you're able. And in the example I used before for creating and maintaining a safe environment, the sort of thing where if you suddenly come upon an issue that is difficult for your client, you can offer them the choice to, hey, do you want to talk about this now? We can reschedule. We need another meeting anyway. So if you want, we can save the tougher stuff for that meeting, or we can power through. And giving them the choice, it can really help clients feel both safer with you and feel empowered that, okay, yes, this is my case. This is something that I get to have control over. So offering choices, even little ones like that, can be very impactful for folks in what can feel at times a very powerless process for them. And then remember to collaborate. This goes back kind of to choice and empowerment. Collaborating as the service provider, you are helping guide the client to whatever their goal is. So if their goal is to become a green card holder, fabulous. Would love to help you with that. So keeping in mind what their goal is and letting them state their goal can help make it feel more like a collaborative process than just saying, all right, this is what we're going to do today and let's just power through. So again, these are just kind of tips and tricks to hopefully make your rapport with your client grow and make it a better experience for both you and your client. And now I will pass it back over to Chelsea.
I think it's Kristen.
This is me. All right. Well, the reason we've brought you all here today is to, of course, let you know that there are pro bono opportunities for you to volunteer to work with an Afghan who has been granted asylum, refugee status, or SIV, and who now needs to apply for adjustment of status. We at VECINA, one of the major things that we do is we would provide mentorship and training to pro bono attorneys who take cases through us. As you can see here, you can sign up to volunteer as a pro bono attorney through our website, and you'll be added to our volunteer pool, and then we'll contact you when a case is available. We can tell you that we know that we have 14 cases, and I'll get into that in a minute, but we do have cases ready to place right now. In addition to getting to work with an Afghan on their adjustment of status case, you get access to our mentorship team, which is me, Chelsea, and then our legal director, Jenny Guilfoyle. And we are there to answer any questions you have about the application or with working with your clients, to how to fill out the application, to questions about Afghans generally. You can contact us by email, or we have office hours twice a week for our pro bono teams. We can also do one-on-one team meetings to talk about cases as needed. Let's see, we review all the drafts before they go out to make sure everything is correct. But generally we let you guys run your cases with your clients. We're just there to provide support. And then let's see, the other thing that we have is our very detailed online courses. We have courses specifically about how to apply for adjustment of status for refugees and asylees. And we're publishing, I believe this week, our course on how to apply for adjustment of status for SIVs. We also have many other courses explaining, also including like courses like how SIVs become SIVs and go through the SIV process. So if you're interested in how your client has gotten to that point, we have those courses. And all these courses are free and available on our website. Even if you don't take a case through us, you are welcome to enroll in the course and go through it. But we highly encourage you to take a case through us so that you can actually put your knowledge to the test. Okay, next slide, please. Oh, I believe with this getting on there, but I believe we have 14 cases, and if I'm correct, we have 9 refugees, 1 SIV, and 4 asylee cases ready to go, and we'll be adding more over the next week or so. Okay. So that is that. Please sign up. You can sign up through that link. I think we put in our link as well, or the link to the ABA's website as well for pro bono opportunities. So you can sign up through either one, and you'll get routed to us, and then our team will be in contact with you. But for now, please sign up, and we'll open it up to any questions. I think we'll start with. I know Chelsea had a few she wanted to answer live, so if you want to start with that, Chelsea, and then we can go through any others that are in there.
Oh, yeah, sure. I know that there's a question about additional forms for adjustment of status. Someone's asked specifically for asylees. So other than that form I-45, what other forms would be needed? It really depends on the condition of your client's case and just certain requirements. So for example, if they're eligible for a fee waiver, they can submit the form I-912. Also, all adjustment of status applicants must submit a medical examination, which is the form I-693. There's differences for asylees versus refugees, so we definitely advise you to either look at our training materials or look at the USCIS website about those particular details, because certain things are needed that are not needed for one group versus the other. So that's really important and not really something we can get into right now, just a couple of minutes left. But those would generally be the 3 forms. And then also if you're submitting as an attorney or credit representative, the G28 to enter your appearance as the legal representative for the record. Also, I'll just tie into that other question we received was, what is the requirement for medicals for refugees? We strongly advise you to just go look at our training courses about that. Refugees generally, they're only needing certain vaccinations, but that's pretty much all the details I'm going to provide right now. So we definitely encourage you to look at our course materials about that, or again, look at the USCIS website to figure out those specific details. And I think those were the ones that I flagged. Oh, actually, we have a question. Oh, sorry, Emily.
I was just gonna say maybe a couple quick questions. Can non-attorneys volunteer? Like, do you do teams or anything like that for?
Yes, that's actually a really great question. Yes, we provide opportunities for both attorneys and accredited representatives as the legal representative, but also for administrative support volunteers. We call them admin volunteers. So we compare whether it's a law student with an attorney or paralegal, or just someone who's not connected to the legal field. We do have opportunities for that. They would be supporting the attorney and the accredited representative, as a team effort. So you can definitely sign up for that as well.
Okay, I think somebody asked if there's links to sign up. Those right now are in the chat. We don't have specific, take an asylee case, take a refugee case, take a SIV case. But if you go to that and sign up, then whenever you talk to the people on our team who do all those arrangements, you can say, I'd really like to take an SIV case, or I'd really like to take an asylee case, or whatever you'd like. There have been quite a few questions about asylees and refugees and traveling back to their home country. Asylees and refugees should not travel back to their home country, even after they get a green card. And the reason for this is that in their asylum application, they have told the US government that they are afraid of being tortured or physically injured or imprisoned or killed if they go back to their home country. And if they then later travel to their home country just fine and they're on vacation, visiting family, having a good time, then that kind of undermines their asylum claim. So we don't want them to get into a position where the US government then later looks at their immigration history and says, well, did you lie on your asylum application? Because that is something that could preclude any other type of future immigration benefit. So the safest thing for an asylee or refugee is to wait until they're a US citizen before they travel back to their home country. Once they're a US citizen, those types of concerns about availing themselves of their country's protection are no longer a concern, so they can travel back then. There are very minor exceptions where they can travel back as asylees or refugees. I'm not going to get into them because they're very case specific. But in general, I would tell your asylees and refugees, you need to wait until you have a US passport.
And just to note on that, for asylees, refugees, and special immigrants, we have heard a lot of safety concerns for folks who, even though they were allowed to come back, they have issues as soon as they land. So even if they can, it doesn't mean that it's a good idea. So it's just another conversation, multiple conversations it'll probably be with your client if they're really really gung-ho to go back.
And then there are a couple of questions about the medical exam. So you probably have all had clients who went through the evacuation process and had medical exams done either before they got to the US or once they were on one of the bases and the camps in the US. And technically, if they have had a full medical exam completed before, those medical exams should still be valid. Now, the issue is, did they have the full medical exam completed while they were at one of the camps? And is that medical exam in their file? USCIS is not going to accept a copy of a medical exam that was completed. They're going to want to see the actual medical exam in the file. So if you have a client that you think could have had a medical exam done, the only way to find out whether USCIS actually has it is to do a FOIA request for their entire immigration file and look through it. That takes time to get that. For a lot of people, it's easier just to get the new medical exam done because there's a good chance that that medical exam did not actually make it to their file. I can tell you in all of the cases where my client, even with a copy of the medical exam that they had done at the camp and showing that to the officer after the interview, they were still RFE'd to get a new medical exam done. So my advice is just to have them done it, have them redo it. They can do it unless you are already planning to FOIA the file and determine whether the medical exam is actually in there.
And similarly to what Kristen was just saying, there was a question about whether medical exams are required now. And yes, there was a change that USCIS in I believe it was last week. The policy might have been before that, a couple weeks ago, but USCIS has said that they will reject I-485s that do not have a medical exam, or as Kristen was saying, if you're able to show, hey, this is in the file already. So that's a change.
We have a couple questions about what do we think will happen in the next 5 weeks. We don't know, to be honest. It's really hard to anticipate what's going to happen. One thing to know is that the adjustment of status process for refugees, asylees, and SIVs is part of the law, part of the INA, part of, you know, our Code of Federal Regulations. So we don't expect anything to change right away as far as them being able to apply and be adjudicated. The big thing that may change is, well, two big things I think that may change is that the expedited preferences given to Afghans may go away. That was something that was done kind of by policy by the current administration. We don't know if the future administration is going to continue to do it. Another thing to be aware of is that when the last time the Trump administration was in place, they required interviews for everybody who applied for adjustment of status. So right now, refugees and asylees generally do not get interviews for adjustment of status, and that has been the practice for all of time except for 2016 to 2020. But we do expect them to re-implement interviews for everybody. So that will slow down the process immensely because they'll have to send those cases to the local field offices for interview. But I do recommend getting things filed as soon as possible. A friend of mine who works at USCIS said they had an internal meeting with their directors yesterday or the day before, and they are attempting to get everything receipted, everything that received with the receipt notice before they leave office. So get things refiled if you can, because they will be on file and then they'll be in the system and they don't have to worry about any changes to filing that may come about.
One question that came in, if the 485 is filed prior to the 1-year asylee approval mark, will USCIS send an RFV asking for additional physical presence evidence? I have not seen that. That's something that we were expecting to happen, but I have not actually seen that.
Yeah, I believe it says in their policy and the adjudicator's field manual, whatever they call it now, that they can take internal notice about people's physical presence, so they can look at their travel histories and see, oh, they haven't left the country, and they can use that as evidence from their A file. Let's see. Somebody asked how our cases are assigned. It depends. A lot of our teams do work remotely by telephone or by Zoom. Some of them do meet in person. It just kind of depends on what they prefer and what their distance is from one another. I believe we provide interpretation services. So we can provide, I know we provide translation and services. Chelsea, do we provide interpreters as well, phone interpreters and all that?
Yeah, we provide all the interpreters, translators, all of that through our current vendor.
Perfect. Yeah. So they don't have to worry about arranging for interpreters or translators. We can help with that. But they're also welcome if they have friends or family members who speak good English, they can go through that as well for an interpreter. But we have all the support in place that you may need to work with your client.
See one note about someone who, even though they may be able to be a legal representative, whether attorney or credit representative, they are newer to immigration or may not necessarily want to take on a case by themselves. If you, we encourage individuals to sign up, and you can note on your volunteer form first, whether or not you want to be legal representative or support, but then also if you want to be paired with someone, we can also pair you with someone, whether or not you signed up with that person, but maybe if you want to be paired with another attorney, if you are a newer attorney, we can also take that into consideration when placing cases. So please know you are not alone. Although I will say we do provide a lot of case placements for new attorneys, whether they're new to immigration or just newly licensed, and they are able to take them on themselves. And that's kind of what our point of our support team is, and mentorship is that we provide you with mentorship throughout, from case placement all the way to adjudication. So please know you are fully supported, and we're here to answer your questions. One other request came about paralegals. Yes, paralegals can sign up, legal assistants can sign up. Pretty much anyone can sign up, as long as their mission and you're dedicated, I should say, to the mission and purpose of supporting Afghans and protecting them. We will welcome anyone who is able to do that, whether or not you have language ability, whether or not you're a licensed attorney or a credit representative. Yeah, just providing pro bono assistance to Afghans. One interesting question came in. I know we have probably less than 1 minute left, but about I-730 cases for family reunification. We do place a few family reunification cases for Afghans. That wasn't the purpose of today's webinar, but we do have some available. So if you are interested in helping a family with those cases, you can sign up and notate that in the form to us, and we will make sure to put you on that type of case.
I'm also going to put in the chat our technical assistance email address. If you aren't able to take a pro bono case through us, but you do still have questions regarding cases that you're doing for your own clients that came in as OAR or OAW parolees, we can answer those questions through our switchboard program. So I'm going to put in the email address to contact us through that, which is switchboardta@VECINA.org. And then we can see if we can help you under that. That is a separate grant program for us, so it's not related to our pro bono, but we would like to put it out there in case we can help you that way. And then I see that there are some specific questions. Anybody with specific questions, please feel free to email us at that switchboard TA. We're happy to talk to you about it that way. The one thing we can't provide any sort of help on is removal cases. So if you ask us about a removal case, we'll probably refer you elsewhere, but feel free to send us any question and we'll see if we can help.
And one other note, we take requests from attorneys and a credit representative. So if you are an Afghan looking for assistance, we would need to refer you to someone else because we can't provide that type of assistance to you directly.
I think that's time. Thank you, Chelsea and Kristen, for your expertise, and thank you everyone for joining us today. And we hope to see you in the volunteer opportunities. Have a great day, everyone.